civil society groups and trade union federation SAFTU protested outside Nedlac over labour law amendments. The proposed changes could make it easier to dismiss workers, especially those on probation or people earning above 1.8 million rand per annum. Now, civil society and unions say these changes risk what they call apartheid-style firings and weaken protections for women, youth and migrant workers. To help us understand the bills, we're joined by Kgomotso Mufamadi, who's a labour lawyer. Very good evening, Kgomotso, and welcome to Power Business.
Good evening. Thank you very much.
The negotiations for these amendments started in April 22, and the 4 proposed amendment bills suggest 47 changes. What are some of the most significant changes that will affect employers and employees?
So you did mention one of them around, employees who are earning over 1.8 million rand having some limited reinstatement rights and having capped compensation in relation to their dismissals. One of the other interesting exemptions is that businesses which are startups, so small enterprises that have less than 50 employees, could be exempted from certain bargaining council agreements. So that kind of leaves their employees out of the protections associated with bargaining councils. Some of the other amendments make it slightly less formalistic or less onerous to dismiss employees in situations of misconduct. For example, some of the amendments speak to the possibility that a disciplinary hearing could almost happen in writing, as opposed to letting an employee come and speak for themselves at a disciplinary hearing and defend themselves. So these are just some of the broad changes that stand to be implemented if these amendments go through.
Now, unions are objecting to several items that are among the proposed changes. One of them that you mentioned was that startups with fewer than 50 employees will be exempt from certain bargaining councils and will exempt from certain labour law practices, and that they're saying that will actually encourage small businesses to stay under the 50 employee mark and fire people. Do you foresee that happening? Is that something that's a concern?
Look, if a business is exempted from a particular bargaining council, it doesn't leave the employees completely without rights. They can then take their disputes to the CCMA, like other entities that wouldn't form part of a bargaining council. So it doesn't leave them entirely out without rights, but it makes it more difficult for them to bargain in a collective sense at a sectoral level, which is what would be happening at a bargaining council, where negotiations, for example, for wages would be happening at a sectoral level and not per business or per factory or per entity. So it would leave them out of that sort of collective fray. It doesn't mean that they don't have labor rights entirely. But I think that the tension, that of course unions have is that the power of workers is collective power. There's power in numbers, there's power in bargaining collectively, there's power in bargaining as groups of employees sort of gathering together and working together to bargain in a sector. So this clearly would diminish some of that collective power.
Another thing that unions are objecting to is the code of good practice and they're saying that this moves away from, as you mentioned, the adversarial pre-dismissal processes. What does this mean actually for employers and employees?
So in an ordinary situation, the way the law stands now, if you are accused, for example, of something at work, maybe you stole something at work or you're accused of stealing something at work, you would then be charged with that offense or that misconduct, and you would go through a disciplinary process, which is generally an oral hearing or some form of process where you're able to give your version of events, right? And not only give your version of events, you're also allowed to question witnesses. So if someone says, hey, I saw you stealing X, Y, and Z, you can say, when did you see me stealing this? Where were you? What time was this? You can cross-examine that witness, cross-question that witness. So if you've got a sort of hearing that happens on paper, where I'm only allowed to say, hey, I didn't do this, I didn't do that, this is where I was, but I can't interrogate the statements of the other witnesses, that would be the main difference. And that's the challenge that a lot of unions would have and a lot of workers would have, to say, actually, I want an opportunity to question people who are giving evidence against me. Now, if we remove that element, I think that the question of fairness of that hearing then comes into play. If this amendment goes through, my sense is that many of these aspects will be tested in court and also refined at court. I mean, I think that's maybe a point that we're not really getting to is that whenever you have legislation, any legislation, there is an opportunity to have that legislation tested in court. But I think what the contention is that it doesn't need to get to that stage. Let's work on this now before it gets to a point where people have to sue the Department of Labor and sue one another to have the courts actually test out and tease out some of these amendments.
And if you'd like to comment on the labour law amendments or ask any questions, the number to dial is 0861 987 000. Also taking WhatsApps and voice notes 083 303 7093 and on X at PowerFM 987. Kgomotso, this has been negotiated for several years, just over 3 years at Nedlac with business, labour, civil society. And so I saw that Nedlac commented to Business Day today that these have been negotiated and some of the parties who were protesting outside had actually been involved in those negotiations. Do you think there's more to discuss, or should these bills actually make their way through the legislative processes?
It's always worth having further discussions, if you ask me, in the context of labor relations. But, we do have certain imperatives, things that we're trying to achieve through these amendments, and some of that is economic growth, right? So, and through the increase of employment in the country. So there's certain reasons that some of these things have come about, and we have those imperatives. We cannot ignore that those are things that we need to do as a country. So, we can't sit at the bargaining table forever, in essence. But I think what is helpful, again, is that these amendments can still be tested in court. They'll be tested at Parliament first. So, even when they go through bill stage, I mean, when they actually pass and become acts of Parliament, they're not likely to be exactly the way they are now. So there's still time for changes. There's still time for negotiation. I think another important thing to mention is that there's always a balancing act when it comes to labor relations. So, for example, people would say, we need to create employment. Therefore, we shouldn't be so quick to increase the minimum wage, for example, because then people will employ less people. So those debates are ongoing in labor relations. I mean, they really never stop. And there are considerations that we always have to take. It's constantly a balancing act in this regard. At Nedlac, at Parliament, through the courts, it is always a balancing act that we a game that we've got to play in this regard.
You mentioned that the bills will go to Parliament. What's the process now? There's 4 of them.
So that's exactly what happens. Once they move out of Nedlac, they have to go through Parliament and be debated at parliamentary level as bills. And then only once they are sort of agreed to, at Parliament, the President then assents to the bills and makes them acts, and then they become acts of Parliament to be implemented. Whether there are court challenges in between is another ball game. I think there are likely to be some court challenges, especially once they become acts. And of course, once they are implemented, once they're part of our day-to-day lexicon in labor relations, our day-to-day work in labor relations, they will definitely come before the CCMA, before the Labour Court, and before the Labour Appeal Court, and probably eventually the Constitutional Court in some respects, where the courts will be able to refine implementation of these pieces of legislation.
And in your view, what problem or what issue were these amendments trying to solve? What were the blockages that were seen?
So, for example, so maybe let's think about the bargaining council, right? So if an entity belongs to a bargaining council and workers in that entity are able to bargain at a sectoral level, it means that everybody in that sector would, for example, be bound to the resolutions that come out of that bargaining council. And, for example, they would be bound to a particular wage level, right? This is how much we pay workers in this sector per hour. Now, I'm a startup, right? I only have 5 employees. And I now need to pay them at this particular level. I can't afford to do that. So what am I going to do? Hire less people. Right? Diminishing the opportunity that I would have to create more employment because I'm now bound to the bargaining council's wage level. So some of these amendments were speaking to that. Economic growth, what role the labor market plays in economic growth, and how can we make it easier for employers to hire easier for businesses to be flexible. Even the issues around dismissal, the time that it takes, the cost that it takes to run disciplinary processes and then have those disciplinary processes also be contested at a later stage. This is really about increasing agility and flexibility of employers. But of course, that has its shortfalls inevitably for workers in some respects.
And as you mentioned, it is a balancing act. Just briefly, what should employers do now to prepare? Because these bills could look very different once they've actually been signed into law by the president.
Yeah, I think for employers, it's very important to take advice on implementation of these bills, implementation of this potential legislation. For some reason, I've started to see employers already implementing some of these changes.
Oh, interesting.
Even though they're not law.
Yes.
So,
Okay.
those
They're very eager.
Another story for another day. But so I think it would be really, really essential to take advice and ascertain which pieces of legislation and which amendments specifically impact your business, because it might not be all of them, and what you want to implement. I mean, your organizational culture also comes into play. If your organizational culture says, you know what, it's actually better for our culture if people can speak at their hearings, if people can express themselves, we want to create a particular type of work environment. Therefore, this particular issue we're not going to implement. So it's also, I think, about taking advice, but in light of your own organizational culture and the environment that you want to create for your workers.
Well, thanks very much for your time, Kgomotso Mufamadi, Labour attorney.